Hello, and good afternoon. I'm here to bring you all back from your reverie there for the last 15 minutes to to an actually more festive environment, if you can even imagine that, because we are going to hear from Professor Andrew Paulus next. I am Lisa Forbes. I'm a judge on the 8th District Court of Appeals, if any of you don't know me. And I am very excited to have been given the opportunity to introduce Professor Paulus. I'm excited because he is really just a true appellate expert. He's also a friend. And so I'm grateful to be able to tell you that he is in charge of the director of the Appellate Litigation Clinic here at the Case Law School. He also teaches evidence, and he coordinates the appellate practice program, as well as serving as a faculty advisor on the moot court for moot court teams. Before he became a professor, full-time faculty here at Case, and that was in 2011. So if anybody's trying to do the math real quick on how old he is. Okay. Professor Paulus was in private practice at the law firm of Hahn, Lozier and Parks, where he got extensive experience in trial practice. And he did that for 18 years. So, and I'm just going to gild the lily on this appellate expertise with one more detail, which is since 2008, he has been a co-author of the Ohio Appellate Practice book that is put out annually by Thomson West. Just to be sure that you have the full measure of appreciation for his accomplishments, Professor Paulus got his JD from Harvard and his undergraduate degree, a Bachelor in Arts from Brown University. So without further ado, I will give you Master Baker and Gardner, Andrew Paulus, to regale us with information about how appellate judges sometimes can conduct fact-finding on appeal. And it's okay. Thank you.
For the excellent campaign that she ran. So I have on the screen a picture you'll probably recognize. It's Simba, the main character from The Lion King. And with Simba is his uncle Scar, who is the evil guy from The Lion King. And in a minute, I'll explain to you why I'm showing you The Lion King. But before I do that, I want to show you a little clip from the movie Reversal of Fortune.
You may not like Klaus von Bülow. You may think he is guilty of something, but I am here to tell you he is innocent. Our new evidence will clearly indicate.
You know there isn't a single case which allows you to introduce new evidence on appeal.
Well, there is one, Your Honor, and you wrote it. Derek. In Derek, you yourself said that a case based on circumstantial theory rather than fact only stands up if no other theory makes sense. The only way to show a better theory is to present it.
Get on with it.
First issue is the impossibility.
So I want to tell you, and I hope Judge Boyle doesn't get upset with me for sharing this, that when I first proposed this topic, I sensed a collective glare from the Court of Appeals at the 8th District for suggesting to actually conduct fact-finding. So I promise you, judges, that I am not going to start encouraging the litigants of the 8th District to start arguing facts in every appeal. But I do want to draw your attention to the fact that there are certain circumstances when appellate courts do fact-finding, and you're aware of all of them. I'm not going to tell you about things that are mostly new to you, but you're going to appreciate that there is a role for the appellate court to engage in assessment of facts, not just sufficiency of the evidence, which of course involves facts, but other things as well. So, first I want to tell you that the pictures that you're seeing there are of, on the left is Klaus von Bülow and his wife, Sunny. And on the right is Jeremy Irons and Glenn Close, who played Klaus and Sonny von Bülow in the movie that I showed you the clip from. And the reason that I showed you The Lion King is because there is a connection here that not everybody appreciates. So Klaus von Bülow was accused of attempting to murder Sonny von Bülow by overdosing her with insulin injections, and she went into a coma. And he was originally convicted. He went up, he got Alan Dershowitz, who was my criminal law professor, and I've always said that the most dangerous place to be in the world is between Alan Dershowitz and a television camera. But Alan Dershowitz represented Klaus von Bülow and then spent the entire semester of my criminal law class talking about that case and almost nothing else. However, there they are together. And I actually talk about the Klaus von Bülow case in evidence, which I know some of the folks in this room will be taking with me next semester, because there is a very significant case about whether or not work product and attorney-client privilege can be waived when the attorney for the client writes a book about the case. And so, as you might imagine, Sonny von Bülow, who had 2 children from a prior marriage, they weren't very fond of Klaus, and so they sued him civilly after he was exonerated for the crime. And I think it's settled or whatever, but Alan Dershowitz wrote the book and it became a Second Circuit case in Ray von Bülow about the significance of that. I'm fairly sure, if I remember the holding, that they held that without the client's consent, the lawyer's publication of a book in and of itself can't waive privilege because the client owns the privilege. All right, so why does that connect up with Lion King?
You have no idea. You have no idea.
Scar was played by the same Jeremy Irons who played Klaus von Bülow, and I'm convinced that that's what they call an Easter egg in The Lion King because of the comment. All right. So why are appellate courts reluctant to find facts? Why do they give you that look when you suggest that it's something that they can do? This part of the presentation for the next 2 or 3 minutes is actually just a cut and paste from something I did 2 years ago when I gave a talk about implicit bias and the role that it plays in wrongfully convicting individuals. And for that reason, we need greater scrutiny on appeal. But that's not what this is about. Here I want to show you there are a couple of different reasons why appellate courts are reluctant to find facts. One is the tradition. That's just not what appellate courts do. The other, perceived institutional competency, like this expectation that trial courts and juries are better. And the third is efficiency. You don't want to give people 2 trials every time they go to trial. The efficient piece is really kind of absurd, especially in criminal cases, because of the 6th Amendment. The right to a jury trial belongs to the defendant, not to the prosecution. So any fact finding that the defendant may encourage the appellate court to do on an appeal is perfectly consistent with our constitutional history. And so to the extent that that's the tradition, it does not bar review of criminal convictions for facts. But we don't tend to do it. But the other thing is that institutional competency. We heard a discussion this morning about the ZC case, which was decided just last year by the Supreme Court, and it had some discussion of manifest weight. And it explains, ZC does, that the underlying rationale of giving the findings of the trial court deference rests with the knowledge that the trial judge is in the best position to view the witnesses, observe their demeanor, gestures, voice inflections, all this stuff that we kind of loop into credibility, and we say that those in the courtroom on the ground can do a better job of that than those who are looking at a transcript. So that perceived institutional competency is the second reason that I say that courts are reluctant to review facts on appeal. But if you look more closely at that, you can find element, please. Thank you. If you look a little bit more closely at that argument, it falls apart. So you've got a witness here on the stand, you've got a jury assessing the witness's credibility, and by the traditional notions of credibility assessment, we are going to assume that that jury can do a better job of telling if Pinocchio was lying than can the Court of Appeals on appeal. But what that does not take into consideration is the fact that there is a transcript of the trial that the Court of Appeals has. And while that transcript does not lend itself readily to things like demeanor and, you know, hesitation when you're answering questions, looking shifty, and all those things that jurors in the room can actually assess. There are different and important benefits to factual review from the transcript, because only with the transcript can you then go back and sift through all of the evidence to see what the inconsistencies might have been, where the credibility problems might be, and why, on further review than a jury can do in the 2 seconds that a witness comes before them on the stand, you might sense something here bigger. So the literature suggests that there's actually a fact-finding competency at both levels, at the trial level and at the appellate level. Not to say that trial courts and juries aren't better at those demeanor evaluations, although a lot of literature suggests that demeanor isn't as good a measure of credibility as people tend to think it is. But in any event, the idea is that there's 2 roles here. They are different roles, they have different functions, they use different materials, and there's room for both. So that's the predicate for why I think that the institutional competency argument simply doesn't make sense. And so we'll move on to efficiency, and this one I really don't have a really good answer for. Where the efficiency argument is concerned, the idea is that if we let everybody have 2 bites at the apple, then it's going to overwhelm the court system, and you're going to have 3 judges on appeal in every case doing the work that was supposed to have been done by 1 judge and maybe a jury at the trial court, and that's not great for our system. I have no answer to that that's going to be satisfying to you, except to say that by definition, any argument about efficiency is essentially a clash of values, right? Because certainly we can all agree that the more trials you give a defendant, the more we will encroach on or approach accuracy, right? The more times you do it, the more times you have to get it right. And so there is a value in doing it over and over again if you're really interested in making sure that we get to the perfect result. That value is in tension with the cost. And so that's basically where we have come out as a judicial system, which is to say that we do not allow 2 bites at the apple. It's too expensive, no matter how many virtues of it there might be. So as a justification for not finding facts, that one makes a little bit more sense if you don't value the accuracy as well as you value the avoiding the costs. So I have here in front of you Appellate Rule 9. Have this here in front of you because I want to draw a distinction between 2 different mechanisms that appellate courts have to find facts. So the first is based on Appellate Rule 9, which is the there we go. That's Appellate Rule 9. And so some of the things I'm going to talk to you about are factual findings that an appellate court makes based upon that Appellate Rule 9 record, which we all know of as the record on appeal. That is the record. That's the only record. 9A are all the filings in the trial court. 9B is the transcript and exhibits. There's 9C and D if you want a statement or something to swap out for a transcript that's missing. But basically, it's all in Rule 9. Everything the appellate court does has to be based on the record as it's reflected in the Appellate Rule 9 context. Or does it? Actual findings can also be made at the appellate level with new information. The appellate judges who are like, what are you talking about? Let me explain, but I'm going to start with the left one first. My presentation just, there we go, thank you. Thumbs up, there is our tech guru, okay.
I did not do it.
Okay. What am I doing, Rob? I'm screwing up.
Just the professor, just the right arrow key every time you want to
That's what I'm
advance.
trying to do, but it's
So you might accidentally with your whole thumb be pressing that middle button. Got to make sure it's only the right arrow.
I'm all thumbs, Rob. Please hit F5 again for me.
Take it from here. Is that okay?
Yeah. Okay, so here's the first example that I'm going to give. Henry the hipster is charged with robbing a bank. The evidence against Henry consists of a single eyewitness, the teller, who initially hesitated to identify Henry as the robber, but eventually testified, that's the guy at the defense table, That's the guy who. Henry says.
I did not do it.
Henry says I did not do it. And he offers into evidence a surveillance video showing him entering a grocery store in Seattle, Washington. The trial was here in Cleveland, the defense took place here. On that same date, November 20th, which I didn't put in the front, but the jury convicts him anyway. So you've got the teller with her shaky testimony about identifying Henry as the bank robber, and then you've got a video of him being in a different place across the country on the day of the crime. So what is Henry's option if the jury comes back and says
Guilty.
okay, so they found him guilty. And as we've already heard a little bit about today, we have a mechanism in Ohio. And by the way, it's unique in Ohio. There are other states that occasionally do it. I've seen Illinois and I've seen New York. But for the most part, if you do a search for manifest weight in all 50 states in the federal system, 99% of the cases that come up are going to be from Ohio. So what makes Ohio so unique? It's unique because we have a constitutional provision, Article 4, Section 3B3, that authorizes manifest weight review. Or does it? What's it say? No judgment resulting from a trial by jury shall be reversed on the weight of the evidence except by the concurrence of all three judges hearing the cause. This is the only reference in the Constitution to manifest weight. And it is a rule of limitation. There is no affirmative right that says you get to do a manifest weight challenge in appeal in Ohio. We infer it by the fact that you wouldn't have a provision that says how to do it if it were something that couldn't be done, right? But this really doesn't give the courts the power to do it in the first place. And it certainly doesn't say anything about how to reverse on manifest weight when it's not a jury trial, where you don't need a majority. It can be 2-1 if it's a bench trial, and there's nothing in the Constitution about that. You'll see it in Rule 12, but you won't see it in the Constitution. So right away, we have steered away from grounding this factual review in something really concrete. We are inferring it from an indirect reference in the Constitution, but it is the weight of the evidence in manifest weight review that is the game. That's what the appellate court is supposed to assess to determine whether or not the fact finder lost the fact finder's way, the 13th juror, as we heard earlier. So I thought it was kind of funny that in 1923, which is one of the earliest manifest weight cases I was able to find out of the 7th district, that the entire decision about whether or not to reverse on manifest weight grounds was just based on who called more witnesses at the trial. It was 8-2. And so whoever had the 2 witnesses won the trial, and the Court of Appeals said, we got 8 more on the other side, plus the plaintiff. We're going to reverse on manifest weight grounds. I'm guessing that doesn't happen much anymore in our appellate system, although there are much more frequent challenges these days to manifest weight than there used to be. So the ZC case says that the thing that a court is supposed to do when conducting a manifest weight challenge is a soup to nuts review of the factual record. The whole thing. Or every potential factual basis that the fact finder based its verdict on that is not sufficiently weighed in favor of the victor to support the verdict on appeal. Now, I've highlighted here, consider the credibility of witnesses, because this has been a source of some contention in the law. It starts with this notion that in weighing evidence, even today, even in 2023, when the Supreme Court decided the ZC case, it said that we have to be mindful of the presumption in favor of the finder of fact. Presumption in favor of the finder of fact. What does that mean? What does that mean? I teach evidence and we cover presumptions in evidence, right? If you have a presumption, it means the other side has the burden of disproving the thing that you come in freely. Yeah,
You can, if it's a presumption, it can be rebutted.
yes. How?
Well, with other evidence.
So not other evidence necessarily that's not in the record for manifest weight purposes. This is the.
Additional evidence.
Well, with the other evidence at the trial, the evidence that came out, the evidence that's in the record, that in the minds of the judges on the Court of Appeals, it overcomes that presumption that the fact finder got it right. So now, my friend. Judge Peter is only one of the authors of this book.
I'm sorry.
Oh, no. And you said that you couldn't afford it, so I'm giving you this copy. I want you to know, Tyler Appendix G of this book is all about standards of review.
Thank you. I'm glad I came then.
We talked about the ZC case, and it's important because it is the most recent case that discusses manifest weight, and it continues to presume that the jury or the judge, if the judge's record got it right. So somehow you have to be able to rebut it, but the case law doesn't really explain very clearly how. It doesn't say how you rebut it. So ZC goes on to say that if the evidence is susceptible of more than one construction, the reviewing court is bound to give it that interpretation which is consistent with the verdict and judgment, most favorable to sustaining the verdict and judgment. This feels to me like a wordier way of saying there's a presumption. Although there's a little bit more specificity in this language, because this language suggests that the appellate court cannot choose among competing inferences and do so inconsistently from the way the jury did it. Because the interpretation that is left to the appellate court is only the interpretation that supports the verdict. Now that's ZC 2023, very recent, current state of the law, can't be right. Why can't it be right? Can't be right. Why?
It contradicts the Constitution.
Not necessarily. I mean, the constitutional provision doesn't give you any rights at all, really. It just says you have to have a unanimous panel. Why can't that be right?
Because
It can't be right because it's not a sufficiency test. Sufficiency tests are the tests where we defer to every inference that the jury found if it's supported by the evidence. And if that's all this is supposed to be, then how is it different? And the Supreme Court has said that it is different. They said in Eastman versus Volke that there is a difference between manifest weight and sufficiency, and that the manifest weight analysis is the same for criminal and civil cases. So why would we do this? Why would we give the interpretation that sustains the verdict? It's basically saying you can have a manifest weight review, but you can't really do it. So I think that's just sloppy language. And in our case here, where Henry the new trial, he wants a new trial, and that's what a manifest weight reversal gives you if you're appealing from a jury verdict. If you're appealing from a bench trial, it could either be a new trial, or even the appellate judges could just put in the judgment that they think the trial judge should have entered. But this is fact finding at its core, and here's the kicker.
I see a site and something I don't like.
It's something you don't like because
Because I think case law over time with the Haas has been
this is
misconstrued.
my thought. There is so much case law that says that when you do a manifest weight review, you don't assess credibility. That's the fact finder's job. Now, we just saw ZC said something different last year, even while it took it away in the same breath. But in the 8th District, there has been a long string of cases that say that you have to defer to the fact finder's credibility determination, and they cite that DeHaas case for that notion. I wish Judge Sean Gallagher were here. Yep.
See, though, it says primarily and not solely.
Yes, it says primarily. Thank you. And to emphasize that, and I'll get back to that in just a second. Primarily, which can mean, by the way, first in time, or more important than the others. So we don't quite know what that means. But DeHaas is a sufficiency case. Yep.
These cases address the qualitative part of it. Like in your example, it's not a credibility question if I have a video of the guy in Seattle.
Sure it is.
right? I know she's not credible. I have a video of the guy in Seattle. There's no
How do you know
question
your
that
video's
like the qualitative nature of how convincing the evidence on credibility is seems to me to be what should drive how much fact finding the appellate court will do.
That's one theory of it. I would just caution you and my future evidence students as well, not to just assume that, you know, what you consider indisputable evidence, like a video with timestamp, it's still the fact finder's province to say that that's not authentic. Or
Do the cases address that idea though? That if there's a big difference to me between he said, she said, and he said, and he's got a video.
Right, but there is no limitation in the law. What you're saying makes sense, that you're gonna have an easier time reversing a manifest weight case when there's such a clear qualitative difference.
I would also feel like the appellate court should be more willing to substitute its judgment in those cases.
And I think it probably is, it's just that those cases don't tend to result in guilty verdicts if the evidence really is so one-sided in favor of the defendant. But I want to get back to the Haas here because, you know, as Judge Forbes pointed out, it says primarily for the trier of fact. But let's see what has happened since 1979, which I think is the first time the 8th District cited to Haas for a manifest weight, even though there is no ruling about manifest weight in Haas. There's a passing reference. I also want to give a little shout out to my former student and now head of the appellate division of the Akron Defender's Office, because this ground zero from citing to Haas is a crib from him. He used that phrase in a recent brief, and I found it so effective that I stole it from Joe Shelton. Now, in 1979, we began this path. 45 years later, and this is why I wish Judge Sean Gallagher were here, just a few months ago, the 8th District basically said, no, DeHaas has no place in a manifest weight analysis. It's a sufficiency case. Done citing DeHaas, no more DeHaas. And by the way, the assessment of witness credibility is very much part of the appellate court's manifest weight responsibility. So that's the decision out of the 8th District from very recently. I hope it sticks. I hope all the 8th District judges continue to follow it, but guess what? The 3rd District 10 days ago. And the 2nd District 7 days ago. Now, substantial deference be extended to the fact finder's determinations of liability. They saw and heard the witness. They can consider the inconsistencies. This is all the institutional competency argument that I have already explained to you is not sound. It doesn't mean the 2nd District was wrong in not reversing that particular conviction. But the analysis of all of this is completely disregarding, or at least substantially disregarding, the important credibility assessment role that appellate courts in fact do have. And it's not based on the ability to observe the witnesses in the courtroom, it's based on their ability to observe the whole record in totality after the fact. All right, so example number 1 turns out to be an example of manifest weight review. I'm going to give you a couple more examples for the left side, and then we're going to turn to adding evidence to record. So example number 2. Cowboy Dan and Cowboy Dave got into a brawl down to the saloon. Dan was charged with felonious assault. At his trial for felonious assault, Dan's ex-spouse testifies during the state's case that Dan was an abusive and dishonest during their marriage, all of that being inadmissible evidence under 404 and 608. The trial court overrules Dan's lawyer's objections to this testimony. All right, so determining whether to grant a new trial as a result of the erroneous admission of evidence under 404B, an appellate court must consider both the impact of the offending evidence on the verdict and the strength of the remaining evidence after the tainted evidence is removed from the record. What's that? You are going to excise from the record the stuff that should not have come in. You as an appellate court have to sit and look at the entire case minus what you've excised and satisfy yourself one way or the other about whether the trial result can stick. I don't know how you do that without fact finding. It's impossible, right? Now, one might say that any time evidence is wrongfully admitted, the appellate court, rather than substituting its judgment for the jury that never heard the case right, should send it back for a new trial every time. What would be the problem with that?
We're doing a lot more trials.
Efficiency, right? That's the reason why you can't do that. But the idea is that you very much have to make a persuasive factual argument in your briefs in an argument if you're going to be arguing that evidence that shouldn't have been admitted taints the entire result. Not only that, but the Morris case goes on to actually switch the burdens here in a criminal case. If affirming a conviction notwithstanding an evidentiary if affirming a conviction notwithstanding an evidentiary, an appellate court must declare a belief that the error was not harmless beyond a reasonable doubt. In other words, if you find a piece of evidence you can successfully argue was not admitted or was not excluded and should have been, and your client is the criminal defendant whose conviction is now on appeal, it is the state's burden to demonstrate that the erroneously admitted evidence didn't taint the verdict. Okay? Think about that. That's a hugely powerful burden shift just by showing an evidentiary. And it means that when you're briefing an evidentiary issue like this, the factual argument you have to make in order to defeat the state's attempt to argue that it was harmless error is intense, right? It's almost like a summation that you have to do to a jury in your brief and potentially an oral argument to convince the court not to find that the error was harmless. And it's actually, for those of you who are defense counsel, even more challenging if you raise it through ineffective assistance. Because if the attorney at trial failed to object to the offending testimony, there is case law out there, it's a little on the bubble, that says you don't get the benefit of the Morris burden flip. If your lawyer doesn't object, then you have the standard Strickland prejudice burden to show that the outcome was probably affected by the lawyer's deficiency, not by the testimony that gives you a Morris analysis. So not only do you have to be prepared to argue these facts, you also have to know which side you're on, right? Are you on the side that has to defeat the harmless error, or the side that has to show it, right? And argue the case in a factual way, very much so, to meet whichever of those burdens you have. Why not always send it back to a new trial? I said before, because of the efficiency concern. But do you appreciate here, to stop for a minute, you've got 3 judges on your panel. You have convinced all 3 of them that this testimony should never have been admitted, at least not during the state's case in chief. Absolutely wrong to admit this testimony. Now, how am I, as an appellate judge, going to decide whether the rest of the evidence is enough, or whether this error makes me feel like it has to all be tried again? I don't have the answer to that question. I wonder maybe if some of our judges can give us some thoughts about how they do it. But if that isn't fact-finding, what is? Yep.
I don't think it's fact finding,
How come?
because I think fact finding is saying A or B, this happened or this didn't. When these reviews are being conducted, and I think there's a little bit of selection bias in the case law, correct? Because the cases where there's the credibility actually in a criminal case is just a little bit down here, the state's gonna lose. It's been my experience in 20 years as a prosecutor. State's gonna lose those, right? The appellate judges never see them. Number one, so we're getting a selection bias. And we are getting, so it's not fact finding.
Well,
Here's the example.
yeah, you're right. It's
go
one
back to
step
Riello.
removed from fact-finding.
It's not what we want to say is fact. Do I have to say yes or no to this? What I think Judge Gallagher did in Riello and explained very well what Tompkins was talking about, I think, because I've read it 50 times. We're trying to get up and talk about it. Was you're looking at the case and whether it makes sense and whether it does that. I mean, they reversed the manifest weight on a case where the victim testified that the sexual assault occurred. They didn't just say, oh, she said it happened, so therefore it did.
So
They looked at the credibility,
Sure.
not of her, in fact, they believed her.
Well, the point here is that the individual subjective assessment of each judge on the panel about whether the remaining evidence is enough to sustain the conviction, whether you want to, I mean, it's certainly not fact finding the way a jury does. I agree it's not A versus B, but you still have to look at all of these facts and decide for yourself whether you feel like the jury was just going to convict anyway beyond a reasonable doubt. You have to understand, appreciate, evaluate, and prioritize the facts that are in the record in order to do that. All right. I'm going to run out of time if I don't keep it moving. I'm sorry. So that takes care of prejudice and harmless error review. Let's look at another one on that side. Raquette was a space engineer for Space Z. She discovered a way to cut the cost of rocket launches by half. At that point, she announced her resignation from Space Z and immediately went to work for Space Z's biggest competitor, Stargate. Space Z sued Raquette to enforce a non-competition provision of her employment contract and sought a preliminary injunction to stop her from working. Parties agreed that the biggest question for purposes of the injunction was the likelihood of irreparable harm in the absence of the injunction. The trial court denied the motion, explaining it was not convinced that money damages would be inadequate to protect Space Z's interest. So we have a preliminary injunction and we have a standard of review. This is just randomly out of the 12th district, but the case law is pretty consistent about this. The preliminary injunctions are reviewed for abuse of discretion, which may be found where a trial court relies on clearly erroneous findings of fact. I'm going to stop there for a second, and I think you alluded to this as well. Clearly erroneous is not a standard that we see anywhere in the Ohio rules. It is a federal concept. It is the standard by which federal appellate courts review factual findings by judges for clear error. There is no clear error provision in any of our source materials, but you still see that it got imported into Ohio law because it is so entrenched in federal law. Judge Claire Dickinson, formerly of the 9th District, who at one point wrote a decision using the phrase clear error, then wrote another decision apologizing to the world for doing so because there is no clear error review in Ohio. Instead, the clearly erroneous standard of review equates to the civil manifest weight of the evidence standard. So said the Supreme Court in State versus Wilson. Now, the problem here, because State versus Wilson was decided in 2007 before Eastman versus Volke, and Eastman versus Volke confirms that there is no difference between civil manifest weight and criminal manifest weight. So the Wilson decision is, woefully outdated in that respect, but it is still good law on this concept that when an appellate court reviews facts, there's a jury or a judge who decided those facts, that review is done under manifest weight, which is what we in Ohio essentially call clear error. And so for abuse of discussion review, where you've got facts that need to be reviewed as part of the analysis, I stuck that in between 1 and 2 actually, because it really turns out to be just another manifestation of manifest weight. All right. And that concludes the fact finding that appellate courts do with the Rule 9 record. Now, I want to show you some things on the other side. Factual findings made from items added to the record. This is, I think, where the agita started to happen. I can envision someone misinterpreting this presentation and attaching all kinds of affidavits and additional evidence to appellate briefs. Judge Boyle does not want to see that happen, and I don't blame her. But there are times when giving new evidence to the Court of Appeals is actually okay. So when are those moments? Let's take a look at a new example, since we made it 1-1A. Sharon Holder, who owned a single share of Hydrocon, fertilizer manufacturer, brought a derivative action under Rule 23.1 against Hydrocon and its officers and directors seeking to block a merger that Hydrocon had announced with Agrocrop. The trial court dismissed the action. Holder appealed the day before oral argument. So it's not in the record. The day before oral argument, the Hydrocon Agrocorp, take out the my mistake, publicly announced that its merger was consummated. The holder thinks there are still steps such as due diligence that have yet to be concluded. So the merger itself, she says, is not yet complete. For Ohio law, when something happens that makes it impossible for a court to grant the requested relief, a case becomes moot. Now, Sharon Holder doesn't think her case is moot because she thinks that there is still an unconsummated merger, notwithstanding the press release from the day before oral. Agrocorp and whatever the other company was, never mind.
Hydrocon?
They say it was complete and that this lawsuit has no further ability to afford relief because you can't unring this bell. The merger's been consummated. Court of Appeals, you need to dismiss the appeal because you cannot decide an advisory case. There's no longer a controversy here. What happens? What happens? There is a fact to be found. And that fact is whether or not it's too late to stop this merger. What happens? When pending an appeal from the judgment of the lower court without any fault of the defendant, an event occurs which makes it impossible for this court, if it should decide the case in favor of the plaintiff, to grant any effectual relief whatever, the court will not proceed to formal judgment but will dismiss the appeal. And such a fact, when not appearing on the record, may be proved by extrinsic evidence. So, when you are asking a court of appeals to dismiss a case because you think it's moot, and mootness can take many, many, many forms, right? It's moot if there's no relief the court can provide. It's moot if a tenant appeals a move out from a forcible entry in detainer action because you can't give the property occurred. It's moot if a mortgagor, if a mortgagor loses the home in foreclosure and the sale has occurred. It's moot. It's moot if you pay the other side a money judgment and satisfy it fully. It's moot. And if you don't obtain a superseding fine and a stay, the other side executes on a money judgment successfully and satisfies the judgment against your desires, it's moot. Those are just a handful of things that can cause an appeal to become moot. And when the fact that renders an appeal moot is a fact that is not in the record, the only way to advise the court about that fact is with new evidence. David, maybe authenticating exhibits if they're pertinent to it. I don't know, what else would you want to see?
Death certificate? Death certificate?
Death certificate, yeah, death moots a case, yeah. Although there is a rule for that. There's a suggestion of death rule that specifically authorizes that one. But yes, it's a fact not in the record. So the idea here is that there are moments, and mootness is probably key among them, when even though a fact isn't in the record, it can still be dispositive of the appeal. And so that is ultimately what Sharon Holder and Hydrocon and Agrocop are going to have to figure out how to do. How to place before the appellate court evidence that will enable the appellate court to make a determination one way or the other about whether this can be undone, which is the sine qua non of not being. All right. So assessing mootness is a moment when factual findings are made from items that get added to the record. Example 4. Gerrymander held the position of official Ohio district redrawer. After years of unsuccessful attempts at redistricting, the General Assembly conferred on Mander the sole and exclusive control to determine political districts in the state subject to statutory procedural requirements. One of which was to publish proposed redistricting plans 6 months before promulgation and to respond publicly to any comments submitted by citizens within 30 days of publication. Karen submitted an objection and Mander ignored it. Karen sued to force Mander to respond publicly, and he countered that the objection was late, meaning not submitted within the 30-day statutory time. So what would you, if you represented Karen, what would you do? What kind of suit would you bring? Mandamus, right? Mandamus, one of the original actions, one of the writs. Mandamus is a remedy that lies when someone has a clear legal duty to do something and has refused to do it, and there is no adequate remedy in the ordinary course of conduct. Right? Mandamus gets filed in the Court of Common Pleas, right?
No,
Gets filed in municipal court, right?
no,
Gets filed in the Supreme Court, right?
yeah.
Yes, it can. And it also can get filed in the Court of Appeals. That's, by the way, an interesting strategic issue that I have never figured out. And maybe those of you who do original actions have a better sense of this than I do. But if you file an original action in the Court of Appeals, then you have an automatic right of appeal to the Supreme Court. I think we heard something about that earlier today. And not a discretionary appeal. If you file in an appellate court, that's the appellate court is the first court, then the Supreme Court serves as the appellate court, and you don't have a petition to get in, it's automatic. So what's the advantage in filing an appellate court if it's appealable to the Supreme Court automatically versus just starting in the Supreme Court to begin with? I get it, there are lots of political calculations that affect that, and perhaps also the possibility that the leverage of an appellate decision might get somewhere even without going to the Supreme Court. But it's never really been clear to me what when you file an original action, how you pick which court to go to. Although maybe starting in 2025, we'll have an easier time deciding. Yes, mandamus is the action here, and it is brought in the Court of Appeals or in the Supreme Court of Ohio. Anybody know what this is?
Our main court.
Everybody know what this is? This is the main courtroom in the 8th District Court of Appeals, from which I believe Chief Justice O'Connor filmed her advertisement that we were all seeing in the days leading up to the election. And by the way, if you haven't been to, what's the number on the first floor that was redone? Three is beautiful now. Is beautiful. So if you have any pull with the court, try to get courtroom 3 or the main courtroom rather than that. If you recognize this room, you probably know what that is.
Judge's bench. That's the judge's benches.
It is the judge's bench. Very good. What's that?
That's where the parties sit.
That's council table. What's that? Taylor sits. Forms to write, the court staff that sits there and calls the case and so forth. What's that? Wow, you guys are good. How can you be upset about the notion of fact-finding appeal when the main courtroom of the How often does it get used?
Once every 2 years.
Every couple of years. Now, the fact of the matter is that when you file an original action, there are, especially at the Supreme Court and often at appellate courts too, magistrates who do the initial fact finding, and magistrates do have the same authority to handle appellate matters under Civil Rule 53 as they do in civil and juvenile and criminal courts. So some of that fact finding is delegated to magistrates in the first instance, at least, in some of the appellate districts and at the Supreme Court level. But there is a courtroom set up for taking testimony. And I've actually, Judge Roby said one time you had to do it. And was it just 3 judges on the bench? And
Judge Mays left, but it was a bond. You know what
Oh.
I mean? Because you can have bond hearings there. with-
Okay, all right. So it wasn't original action.
Yeah, it's 3 judges up there,
Okay.
yes.
Judge Mary Jane Trapp of the 11th District, a year or two ago, they had a really complicated major original action and days and days and days of testimony. She started to tell me what it was about, and my eyes glazed over very quickly, so, which is probably the case in many original actions, by the way. Just seeing state ex-rel makes me kind of like want to. So the interesting thing about this seat. It doesn't look a whole lot like a witness stand when you blow it up and reduce the, what do you call that? The resolution. What does it look like?
Chair. A chair.
A chair? Anyone more imaginative? No, you're imaginative. I didn't mean to suggest. I can't hear what?
It's a Pac-Man ghost. You came back.
I'll show you what it is. Let's first put original actions over here where they go. And so, full circle with the Lion King. Actually, that's going up Simba, not Mufasa. And that is the antidote, by the way, to the appellate judge who is not too happy about your attempt to argue facts or introduce facts. Obviously, if it is a direct appeal and there are no issues of mootness and so forth, the only potential factual arguments that you're likely to make are either the manifest weight argument or the harmless error argument, maybe a fact related to a discretionary ruling. But the idea is that, and so the larger point for me here, and I actually am very grateful to the court for not only the chance to talk to you about this, but also for the chance to think about the reaction that the topic first engendered, because this is in fact not the facts on appeal thing, but when you suggest to people something that runs counter to their intuition about what they do or what the courts do or what the legal profession should do, you sometimes run into established reluctance to veer from our canons of what we think the law, how the law works. And so there is a canon that, trial courts find facts, appellate courts look at the law. And generally that's true. But it's important to push beyond the limits of those canons when the law permits it, not because if you don't, then you are framing your arguments and you're putting yourself in a smaller hole than you really need to. My point here is that there are many opportunities, whether it's from the existing record or in the instances when you can add to it, to make factual arguments. And I think if you read the best briefs that are out there, even when it's not a manifest weight issue, the facts are so important in persuading the judges on legal questions that if you're not really using those facts to your advantage, then you're missing opportunities, even where the issue in your case is not a question of whether the fact was right or wrong. So I'm 5 minutes early. I apologize for not giving you the full hour of time, but yeah, I'm happy to take some questions. Yeah. Hey, Maria.
Hey, how are you? A little bit different than your presentation, but in terms of the facts and the record and things like that, if you're on the other end of it, you've got say it's the appellee arguing things that aren't in the record, told that could have been. What is the you know, and say your time, say you didn't reserve any rebuttal time or you have very little rebuttal time. Sometimes the bench runs you out, right? So say you've got, you know, 30 seconds rebuttal time. What do you do in terms of new facts or that kind of argument? Someone comes up, it's totally outside of the brief.
So, absolutely, you're coming at it from, more of the perspective that most people tend to think about, litigation. And so the first thing about that I would say is that you will have, by definition, a very receptive panel of judges to whatever you're able to say in the time that you have. Because if you give them the notion that there are facts being described that are not in the record, there's no more winning argument than that. So the question really is about, in the short time that you have, how to collect whatever facts you heard and whether even to try to go through them all, which you might not have time to do, or whether to simply say, 50% of the facts that we heard from the other side are not in the record. I don't have time to explain to you which ones they are and why they're not true, but it's really important that we decide this case based on the facts that are in the record. Here are the ones that matter that are in the record. We should admit something. But correct me if I'm wrong. I've never been an appellate judge, but I would imagine if somebody started in an oral argument explaining to you that the facts that you're hearing from one of the oralists aren't in the record, that would be an immediate eyebrow raiser.
Usually stop.
Yeah.
You talked about Morris and this burden shifting situation. With Morris with the burden shifting, is there something similar in the civil world where the burden shifts if the plaintiff still has, they've got the preponderance of the evidence?
Actually, no, there's not. The appellant, unless you're operating under some other presumption in the law, the appellant always has the burden of demonstrating that the error was prejudicial in a civil case. But you did remind me of something that I forgot to mention. And that is that the Morris decision that says there's this harmless beyond a reasonable doubt burden on the state. In Ohio, that is true of evidentiary errors as in Morris and probably many trial errors that can occur. But it is not true in the federal system. In the federal system, there's a case called Chapman, which makes clear that constitutional errors that occur in a federal trial are subject to the same standard of harmless beyond a reasonable doubt. But evidentiary errors that occur in federal court in a criminal trial, even if they're preserved, it's still the appellant's burden to show the prejudice. And so Morris actually, I think it was Justice Lanzinger at the time, who basically said, we don't have a distinction in Ohio between constitutional and non-constitutional errors, so we are going to apply the harmless beyond a reasonable doubt standard to everything in criminal cases.
During your presentation, you went through many examples showing how it's appropriate in certain specific examples of when an appellate court can fact find. Are you suggesting that should be taken a next step and appellate court should just generally but second guess a jury as a matter of course, as in addition to those specific limited situations that you went through? So
I gave a presentation 2 years ago at this seminar. And yes, I do think that the degree to which our legal system, the criminal justice system, is infected by wrongful convictions that are themselves the product of implicit bias, that there should be a greater role for appellate courts when there is something going on that smells funny, even if you can't put your finger on it, and say it's just got to be tried again. It's another conversation that's very controversial. I gave it a couple of years ago, but yes, I do think that's not the extension of this. That's a separate topic because it's very specific to the criminal justice system and to wrongful convictions because of the disproportionate way in which people of color are convicted.
Going back to your fact finding in civil cases, I mean, when you go to the motion for summary judgments, we often see that proper 56 evidence isn't attached to the briefs down below, but yet maybe a trial judge used it in its analysis, but then when it comes to us, it is improper evidence. So now we have to, I hate using the word fact find, but now we have to decide how does it affect that ruling on that summary judgment?
Yeah,
with the standards of viewing the evidence in the most favorable light.
The easy way out for you on that might be that I think if you don't object to the admissibility of summary judgment evidence at trial, and the judge then relies on it, that it's forfeited for appeal.
What about in the summary judgment realm in the trial court level? Did they need to object to it?
That's what I mean, yeah, like if you file for summary judgment and you attach unauthenticated documents, for example, I'm fairly sure that unless the other side objects to the unauthenticated documents, that they are then part of the record that you can consider. In other words, that the impropriety was forfeited, I think.
Thank you very much for your presentation. It's far above my head because I don't practice in appellate court very often. But one of the things that I thought about when you talked about implicit bias is the Mumia Abu Jamal case that went on for decades, actually. And I had a tiny role in the appellate part of his, when it was remanded back to the same judge who made some really pretty egregious errors. If it comes back to the same judge, where is the justice that, I mean, does it go bounce up again to the appellate court?
Well, if there's error, certainly somebody can try. Some jurisdictions automatically assign a new trial judge to a remanded case. Ohio has never done that as far as I know. It'd be nice for the successful appellate not to have to kind of walk down between the legs when you go to the first case management conference or whatever.
So I have a matter where someone's appealing a denial of a motion for sanctions. And they, after the ruling came down, they ordered transcripts of hearings that were held back in 2021 and 2022. And they want to make that part of the record to argue that the trial judge abused their discretion in denying the motion. And it sounds to me like that, given when these hearings took place, they weren't cited or ordered prior to. It's from the same action.
From the same action, and they were ordered, for purposes of appeal, they're in the record. Question is whether they have any bearing on the issue.
Right, they weren't provided though. They weren't provided to the trial judge to consider when they filed their motion.
That's a problem for putting it in the record.
Okay. Okay.
In the record. Thank you very much.